Welcome to the impact of the new Labour Law Amendments and Code on Dismissals, a webinar exploring key changes in labour legislation, dismissal procedures, and compliance requirements. This session is essential for employers, HR professionals, and employees seeking to stay informed and compliant.
Hey everybody, and welcome to our webinar this morning on the impact of the new Labour Law Amendments and the Code of Dismissals on the workforce and the employer. I am Natalie Zimmelman. I am the CEO of Wits Plus, which is the company that delivers the short courses offered by Wits University. One of the courses that we run is the Labour Dispute Resolution Program in partnership with the CCMA. That course and that partnership has allowed us to put together this fantastic panel that we've got here today to discuss this really topical and valuable issue this morning. So I'm really grateful for everybody that has joined us on this panel today. And so while I'm there, let me introduce all of our panel members. Welcome to Mr. Peter Venter. And if you can all join me in wishing him happy birthday today as well. And the fact that he has given us his time today on his birthday, we are very grateful. Peter is a senior commissioner at the CCMA in the legal services. He holds a B Juris and an LLB from UNISA and was admitted as an advocate in 2018. He has extensive experience in government and the trade union sector and has previously practiced in at the Bloemfontein Bar while serving part-time as a senior commissioner at the CCMA and in various bargaining councils. Welcome, Peter, and thank you for joining us.
Thank you, Natalie.
We are also joined by Comrade Mahle Zelani, who is a legal officer at COSATU, serving within the Secretariat at the head office. She's an admitted attorney of the High Court of South Africa and has a background in litigation and, as you can expect, extensive courtroom experience. Her work spans legal advisory, policy engagement at NEDLAC, and supporting workers with workplace grievances, combining her strong legal expertise with a much more people-centered approach. We are also joined by Mr. Adil Patel, who is a director of the Labour Law Unit at Cliff Decker Hofmeyr. And thank you to COSATU, Cliff Decker Hofmeyr, and CCMA for supporting this webinar today. Adil is a director and the National Practice Head of Employment Law at Cliff Decker Hofmeyr. He's a recognized thought leader and advises clients on commercially signed compliance solutions aligned with business strategy. He's also a regular guest lecturer at Wits University and very much respected as a speaker and lecturer. And he's known for delivering practical, engaging insights that resonate with both professionals and students. We will also shortly be joined by Professor Mohammed Ali Chikte, who is a senior lecturer at the Wits Law School. He is the convener of the Labour Dispute Resolution Program, and he teaches labour law and alternative dispute resolution at LLM and LLB levels. He coordinates the courses for Wits Plus and has extensive experience also practically as a former CCMA commissioner. He's of course published widely and has presented internationally and has previously served as chairperson of the Companies Tribunal and a member of the BCCSA. So as you can see, everybody, we've got a tremendous panel with us here today. I'm going to just touch on a couple of housekeeping issues, please, before we get really into some of the presentations. We've got a large group of people watching on the presentations today. So can I please ask that you put your questions into the Q&A. We're going to be doing our best to be watching all of the Q&As, but we might not notice all of the questions if they are in the chat section. So use the chat section for discussions, viewpoints, etc. But if you've got a question that you want us to answer, please make sure it goes into the Q&A section. We will try and answer as many of the questions live as we can. But if we are not able to answer all of your questions, we will ask these esteemed panelists to give us some written answers, which we will share with you along with obviously the recording of this webinar. So don't panic if your question does not get answered within this very short hour that we have available. I'm hoping that we are going to be having some presentations and discussions for at most 40 minutes so that we allow a decent amount of time in today's session for some Q&A and to get your thoughts. So let's jump right in. I'm going to start with Peter, who's going to give us a high-level overview of what these changes are and what they mean to the CCMA, and specifically what impact and challenges that has created for the CCMA. So, Peter, over to you. The rest of us are going to turn our cameras off, and you're welcome to share your slides now.
Thank you, Natalie.
We'll put the slides into the show. Thanks.
Yeah. Can I just ask, are you able to see the slides on your side?
Not yet. I'm bringing it to the screen. I can see now. Thank you.
All right. Good morning, everyone. Thank you for inviting the CCMA. We really appreciate the fact that we can be here today to play part in this session. I was asked to keep it very brief, less than 10 minutes. So if I go too fast, please accept my apology for that. We have quite a lot of slides, and I might even skip some slides just to save us some time. Like Natalie said, you are welcome for Q&A, and then even afterwards, if there are any issues, we'll gladly, you can liaise with us and we'll come back to you. So without any further ado, if I can go down. All right, so you might or might not know that there's a new code of good practice on dismissal, which was promulgated on 4 September 2025. What is important here is that this new code of good practice replaced Schedule 8 in the LRA, as well as the code of good practice on dismissal relating to operational requirements. So it's really an attempt to bring both of them together in one document. So if I can briefly say, the code attempts to provide a clear and consolidated guideline for the minimum requirements for procedural and substantive fairness. A lot of focus in this code is it allows small employers some flexibility in applying procedures. And it also distinguishes between requirements of fairness in matters of poor work performance for senior employees versus more junior employees. And important, the new code also gives guidance relating to matters of probation. Okay, the draft code came out in January 2025, and the CCMA also gave inputs from maybe more perspective from our commissioners. Some of the inputs that we mentioned are the definition of what is a small, what's a medium, and what is a large business or employer, and also the use between small business and small employer. There's not consistency in the code regarding that. And the CCMA also emphasized the need to clarify the meaning of concepts and to provide additional guidance on matters related to consistency, what is consultation, and the distinction between dismissal and automatically unfair dismissal. Small business, like I said, a lot of emphasis on the small business. This new code of good practice provides that the code should not be interpreted as requiring small business to comply with obligations that are not practical or feasible. Those two words are the buzzwords in item 3 of the new code. So it gives flexibility for small businesses who do not have their own HR department, who don't have money for lawyers, attorneys, advocates, etc. So it makes provision that discipline should be applied more flexible. Now, if you compare the 2002 code with the 2025 code, item 11, which deals with procedures, more or less the same. The parts marked in red are the differences. The new code basically states that an employee, when he's faced with discipline, should be given adequate and reasonable opportunity to respond and given an opportunity to make representations. Investigation inquiry appropriate to the circumstances. You will also see that the code does not compel small employers to have this formal investigations, affidavits, long-winded disciplinary hearings. It also provides for notification in your language, and very important, it justifies non-compliance. In other words, employer can deviate from the code if there is an exception to the rule, and each case will be handled on its own merits, obviously. Turning to item 8, substantive fairness. If you look at the old code, it gave certain issues that a commissioner must, or even a chairperson in a disciplinary hearing, ought to consider. I'm not going to read it. You know what they are. The difference in the new one is that in the 25 code, it also now makes provision for the importance of the rule or standard at your workplace. And then also what was the actual or potential harm caused by the employee's contravention. Right. So I think, let me just go here. All right, then if I can quickly refer you, I'm going to jump between the code and the LRA proposed amendments. Section 188 of the LRA, we all know that it deals with a fair reason and fair procedure for the dismissal. The proposed amendment to that is simple, a new subsection 2 that states that any person considering, which will now obviously be a commissioner, whether the dismissal was fair must consider the relevant code. And then it added subject to subsection 3. And subsection 3 says that in addition and stipulate, it is an addition and stipulates that a fair procedure is one where the employee has been given adequate and reasonable opportunity to respond. And crucial, subsection 4, the section does not apply to new employees during the first 3 months of employment or during longer period of probation. I'll come back to that later, and I'm sure my colleagues are also going to say they favor this, and obviously from the other party they won't favor that. If you look at section 188, it gives greater flexibility during probation period, and also it gives greater flexibility to the employer party, especially small business. Sanction of the dismissal. The new code also gives us the same as the previous code. This time it's in item 9. It discusses what the sanction of a dismissal is, and it gives some requirements that any person that considers whether dismissal was fair need to consider those circumstances. I'm not going to read it. We'll make the slides available at a later stage. Same with dismissal related to industrial action that does not comply with the LRA. The new code also gives specific factors that are relevant when assessing the seriousness of the contravention. I can just maybe highlight that quite interesting is the new code tells you there must be a first ultimatum given to striking employees, and that it would in most instances be unfair to dismiss strikers if they adhere to that first notice that was given to them. Okay, this one I'm just going to skip some. Then if I can go to section 191 of the LRA proposed amendment, in essence, what it deals with, at the moment, it does not give the CCMA jurisdiction to deal with specific examples of discrimination. There's now an addition in subsection 5A, Roman 5, that stipulates that the bargaining council or the CCMA must arbitrate the dispute where the employee has referred the dispute to the CCMA in terms of section 10(6)AA of the EEA, and the dismissal dispute can be determined jointly. Subsection 11A, capital A, is an addition and determines that the employee is dismissed for a reason contemplated in section 187D, E, or F may elect to refer the matter for arbitration or to the LC. And then those subsections, 187D is when you are dismissed for exercising a right in terms of the LRA. Then 187E for pregnancy, 187F, direct or indirect discrimination on an arbitrary ground. Then very important, remember this only applies to employees earning under the statutory threshold as in the BCEA. Just go on, 193, quite interesting. A lot of debaters will follow this. Subsection 1A and B and subsection 2 deal with reinstatement and reemployment of all employees. So at the moment, the commissioner has a discretion. He can either give compensation or reinstatement or re-employment. The new additions to or proposed amendments to the LRA will take some of this away, and reinstatement and re-employment would not be available as remedies for employees earning more than a prescribed amount. The prescribed amount is 1.8 million. In essence, it simply means if you earn above 1.8 million, the commissioner cannot reinstate or re-employ you, but can only give compensation. Section 194 amendment proposal. Compensation for the dismissal that was previously substantively unfair. As you know, it's 12 months compensation. For automatic unfair dismissal, 24, unfair labor practice, 12 months. Now, what comes into play now is that subsection 1 is substituted and replaced with an addition that reads, you can only give compensation to a maximum of an amount that may be prescribed by the minister. And like I said, currently that amount is 1.8 million. So it also therefore limits the powers of a commissioner in giving compensation. Okay, section 188. All right, section 188, there are also some amendments there, which I'm not going to deal with due to time constraint. From our perspective as the CCMA, the new code is clearly an attempt to codify many decided cases. You will remember Avril Elizabeth, Highveld District Council, Semenya versus CCMA. All these cases more or less said, look, we were wrong, some of us, in a grant or requiring all the strict disciplinary procedures. It's not a criminal court, so there are departures from formal processes, and the courts endorse that. So this is more to align with those judgments. What caused these rigid requirements? It might be chairpersons, it might be employers or unions, and even commissioners. We place too much emphasis on procedures, I think, that should align with these huge investigations, etc. What is now required is practical and feasible. In other words, if you're a small employer, that's not required from you. Important large employers may still be required to follow disciplinary codes and procedure if you look at the code of good practice. Now, here's the issue. What is a small employer or business, and what is a large employer? I think our commissioners, I feel sorry for them. They're going to be faced with this, and they've got broad discretion at the moment. But as we all know, too much discretion might also create uncertainty. So you might have the one commissioner saying, yeah, 10 employees for me is big. Another one will say that's a small employee or small employer. So we don't know, there's no definition in the code of what is a small business. We can look at the Employment Equity Act. There's some definition in there. National Small Enterprise Act's got some definition similar with the proposed Section 9B of the Basic Conditions. We're not sure how it's going to pan out, whether commissioners are going to use this as guidelines. What's really going to happen within the CCMA, because it's a grey area, it's not certain. We will focus a lot on reskilling, training of commissioners, awareness campaign, etc. So our commissioners are going to have, to go the extra mile in considering what is small, what's big, that type of thing, and when are procedures not really required. The first 3 months when a person is still on probation, I just hope we don't go the route of the United States where you can almost hire and fire at will, and it's yet to see how our commissioners are going to interpret that. So that would be my presentation. Thank you, Natalie.
Hi, Peter. Wonderful, and thank you very much for that. And I'm sure we're going to see a raft of questions coming from that. Welcome, Prof. Ali Chikte. Peter's given us a sort of high-level overview of what those expected changes are. Is there anything that you want to add at this stage to that presentation, and just give us your sense of the changes and their impact?
Well, I've got a presentation. Should I put it up, or are you concerned about time? Let me just try.
But go through quickly, because I think that Peter's been good in giving us a sense of this.
I think my presentation is quite long, but I'm going to rush through it.
Please.
Am I sharing? Can you see my screen?
We can see your screen, but we're seeing ourselves again.
You can see a million screens, right?
Yes.
Now, are we okay now?
Yes, go to presentation mode.
Right. I'm going to talk very quickly about the presentation and the code, and I think Peter's said some of the stuff already. I think for us as a university, before I start, I think it's important. The talk was very important. I think Natalie said it as well for WITS Plus, because these are the first. I mean, there's always changes to the Labour Relations Act, but I think there are fundamental changes and shifts that are being made with the new amendments. I'm going to talk very quickly about them. As I said, the slides can be made available. If you look at some of the significant changes that were made, one of the major changes, and I think it's important, is the parental leave one. I think the Constitutional Court has said that that the way in which we deal with maternity leave it discriminates against, I suppose, both men and women. I mean, so now both parents are entitled to share the 4 months in 10 days. And there's some nice things with regard to the new amendments when it comes to if you're a single parent, with regard to surrogacy as well, with regard to adoption that's increased to 6 years. I know I'm going a bit beyond the misconduct, but that's a very nice amendment. I think it's welcome that they're going to give parties a choice in how they want to use the parental leave, and it's up to date with regard to equality that's happening. Another important change is the gig workers, Uber drivers, 60 drivers, those checkers, motorcycle bikes, whether they can be regarded as employees as well. And I think that's another important change in the amendments. The onus will be now on the employer to prove they're not employees. So I think that may it may benefit employers in getting protection, but also the flexibility what one wants in the workplace may be affected by that. And I think there's going to be a lot of issues about whether or not they can be regarded employees. Also, how are they going to enforce their rights? How does an Uber driver go on strike, for example? There's also other amendments that favor the employees. Basically, yeah, we spoke about that one. The severance pay double, I think that's an important change. I think it favors employees in that when you dismiss employees now, the minimum will be 2 weeks for severance pay. That's going to cost employers a bit more, but I think 1 week for every year worked is very little when someone leaves. But at the same time, it creates a lot of pressure on the employers. So there'll be some interesting debates on how one's going to deal with severance pay in the future. Probation employees, and I think CCMA said it well, that how are we going to deal with probation employees? Does it mean in the first 3 months you can hire and fire as well at will? Does it give probation employees the protection it needs? Are people going to hire and dismiss people before the 3 months? I think that's going to be quite interesting to have a look at. Limits on dismissal as well. I mean, and I think Peter said it, those who earn above 1.8 million can no longer claim reinstatement. I think that that's a big change. I don't know, I mean, do those employees need the protection? Are they high-end earners? How does it affect those who earn less than that? Does it allow people to hire and fire those high-end earners as well, knowing that you can pay them off without reinstating them? So I think that's also a bit of a controversial change. Another important amendment is new small businesses don't have to be bound by bargaining council agreements. And I think that's an interesting change because if you work for 2 years, you don't have to be bound by the high wages and, well, I don't know if it's high, but wages agreed to at the bargaining council that allows your business to grow. It creates employment. But one's got to, yeah, so that's another nice amendment. And other amendments that may affect the CCMA, I suppose. The nice one is the sheriff's fees. Sometimes you get an order, but who's going to actually enforce that order? Now, the CCMA can assist with sheriff fees. I don't know if the CCMA has the budget for it. I don't know if the sheriff's fees are going to be less than what they normally are, but that comes at a cost. But it's a good amendment. It understands that once you have an order, the order needs to be practical. If you can't enforce it, and you can't afford sheriff's fees because now you're unemployed, the CCMA can assist if you earn lower than a certain level. There's also other changes. There'll be CCMA can now deal with harassment claims directly. The expanded definition of employee will give the CCMA much more work and interpretation of those provisions. And I'm not going to go through all of these things. We spoke about these things. 189A retrenchments, the facilitation will be dealt with directly by the CCMA, and the jurisdiction, as I said, the extended jurisdiction will give the CCMA more work. But I think it's Yeah, and that's with regard to the new amendments. Just a snapshot of it. So it's an exciting change, the new amendments. If they come to fruition, new form of employees are being recognized. Maternity leave is being recognized. The CSM's work is being expanded, and I think it's going to be lots of challenges for the union and for the employer if those new amendments come into play, because new unions are going to have to recruit those new employees to increase their numbers. If they're going to be recognized as employees, so it gives them more protection as well. The CCMA commissioners there'll be much more training needed at CCMA level and at WITS Plus. With the labor dispute resolution program that we offer for prospective CCMA commissioners and those in practice, I think one needs to be able to assess those particular provisions. The code on dismissal came into practice last year, and I think, as Peter explains, some of those provisions are still a bit vague. With regard to incapacity, we know there needs to be an investigation, a right to respond. But the thing with incapacity is that senior employers, again, those who are senior, who are expected to know how to do their work, they don't have to be given warnings anymore. You're hired because you know your job. You don't need all the specific protection that are given to other employees and not as senior. So that's one of the changes that's there. Let's go over it again. Don't need,
Ali, while you're going through your slides, there's a question on when the 2-week severance pay for retrenchment, when is it effective, and is there any formal communication?
I think that's part of the new amendments. That's not yet in law. What they said is that they're going to have a balance. What they're going to do is they're going to say, look, once it gets, if it's passed as a law, that's still going to be subject to discussion. It still has to go through Parliament. If it's passed through law, I think it will apply prospectively, not retrospectively. So you work out your retrenchment pay based on your severance pay will be 2 weeks from the date the law gets implemented, and it's a minimum 2 weeks. You still have to consult on those things. Thanks. Operational requirements. I think when it comes to operational requirements, we need to understand that operational requirements. In one section in the code, it must be a measure of last resort. I think that's going to be subject to interpretation. What's a measure of last resort? And I think that there'll be challenges there when it comes to substantive fairness, because there'll be disagreement what's last resort between the unions and employers. When it comes to determining substantive fairness for misconduct, determining substantive fairness for misconduct cases, I think there's a few new provisions that were added in Schedule 8, and I think the CCMA spoke about that. So when people are being trained with substantive fairness, when you're narrowing the issues, determining what issues are in dispute, you need to have a look at the new schedule on substantive fairness that's in play there. How serious is the misconduct is one of them. You've got to look at how serious the actual misconduct is. Also, you've got to look at whether the employee showed remorse in their actions as well. That's another section that's changed. The other aspect is before, as a commissioner, one used to normally be quite strict with procedural fairness. If there's no compliance with any of those aspects, one would actually find dismissal to be procedurally unfair. But now there seems to be a shift away in terms of the new code as well. Inconsistency, for example. Before, if you treat people differently, your dismissal would be substantively unfair. But now there's a little footnote in the code which says that the seriousness of misconduct and the intolerability of the employment relationship will affect as one was determined when dealing with consistency as well. So even if you treat people differently, if it's very serious, they allow you to move away from it. How that's going to be interpreted by the CCMA, we'll have to wait and see. To what extent can you deviate? How serious is it, the relationship intolerable? I think there's going to be quite a few cases on consistency because of that little footnote that's at the bottom there. Misconduct, procedural fairness.
Sally?
Yes, time up. Hello?
Just about, carry on.
Okay, I'm not going to go over it in detail. I'm just going to say, look, procedural fairness, we know that when it comes to small businesses, one can be a bit more flexible. What that actually means with regard to procedural fairness. And also there seems to be, if you look at the structure on procedural fairness, on the one end, it says medium businesses and large businesses need to have written rules. On the other end, it talks about us being more informal, being more flexible. And I think that's where a lot of the controversy is going to come into play between unions and employers. What is the informal process? How far must one go? What is a small business? What's a medium business? What's a large business? I mean, when can you deviate from procedural factors? I mean, and that's where the courts are going to have to give us some guidance. They're going to have to give the CCMA some guidance, and I think that's where the unions and the employer and employers are going to be in conflict. I mean, what is a fair process? Before there were strict guidelines. CCMA would apply strict rules. You know, you give a notice, you give notice. I mean, there's a whole lot of guidelines there that we're all familiar with: notice, representation, time to prepare, and so forth. We need to actually know, there'll be lots and lots of disputes and interpretations on what the code is actually saying with regard to procedural fairness. So I'm going to go through everything. I think where the dismissal... Okay, time's up. Just last sentence that, look, there's a lot that we can discuss on this particular thing. Thank you. I'm not going to talk anymore.
You are going to come back in later. And there's also a question from Bruce Lee that is in the Q&A that I'd appreciate if you could perhaps give a written answer. Well, I come now to Comrade Amakle. Ali has started to touch on the issues of the dismissal procedures, and I know that that's something that you want to speak to a bit. But how have these changes impacted on labour specifically, or you think they're going to impact, both the good and the bad? And as Peter has touched on in the CCMA presentation, how is this also impacting on your work as a representative?
All right, thank you so much, Natalie. Good morning, everyone in the platform. I'm going to jump straight into it. So my colleagues have spoken before me, my co-panelists have already touched on a summary of what either the already gazetted amendments are, as well as what the proposals are. Right. So it is important to note that the current schedule, as gazetted last year in September, follows one that was last gazetted or amended in 1999. So we've been operating on that Schedule 8 for this long, and then in 2025, there are amendments proposed. So you can already imagine the impact this will have on labor, particularly shop stewards or representatives, because ordinarily you are trained in the old Schedule 8. You are familiar with the processes of the old Schedule 8. So it really requires a big education rollout program to ensure that also what has been years of education, we're able to shift the syllabus to now suit the amendments that have now come into effect, but also being able to take into mind or consideration the proposals and the discussions that are still ongoing, pertaining some aspects of the Schedule 8 and the LRA and all other labor legislations, really. Now, just to zoom into the particular ones that are affecting trade union, or at least organized labor the most, there's the clause on the Schedule 8 now that speaks on small businesses and how they cannot be reasonably expected to engage in time-consuming investigations or pre-dismissal processes. As labor, the problem with that is it seems to create a vacuum, or what it intends to do is to make the dismissal processes or conduct easier for the employer, whilst it creates a vacuum for the employee for standard procedures. I know that the discussion of we wanting to move away from criminalizing the processes of dismissal. However, the reason they were in that format is because one, if you look at the effect of this dismissal, two, to ensure justice, or to ensure that whatever happens within reasonable and justified processes and procedures. We wanted to shy away from the autonomy of employers to be able either to dismiss or to retrench as and when they please. So now when we find this now amended Schedule 8 or the repealed Schedule 8, the relaxation it creates is very worrisome for labor, because it relaxes rules for us so much for employees that it makes our job a bit more difficult. It is a task we are up to, of course, but the relaxation itself is a relaxation that to an extent as labor we don't find justified. If you look at the previously repealed schedule, you will also see that we're already having procedural defects. A lot of our cases bordered on procedural defects on the part of the employer that would find their way to the CCMA. So now, if already we had a strict procedural methodology and it was already not being followed, it was already being disregarded by some employees, you have now further made it easier for them to further violate, or rather to shy away from procedures that are set out by the LRA when it comes to how they treat their employees and how the dismissal processes go, right? And then the Act further speaks on disciplinary measures and how employers may depart from these rules if there's a justification to do so. And then in terms of for procedure, the schedule also holds that its purpose is to ensure genuine dialogue and an opportunity to reflect before any decision is taken. This intends to see the employee being given adequate opportunity to respond to allegations of misconduct. The very same section, however, holds that employers in exceptional circumstances cannot be reasonably expected to comply with these guidelines, and that they may dispense with them, with some of them or all of them in their entirety. Now, again, this will go back to my previous submissions to say, now, if we are putting a code, relaxing it because we want to move away from the criminal structure of it, and then we put this more relaxed code with further relaxation that says, oh, this is now the new code. However, you really don't have to follow it if it's justified. Who then defines the justification? Is it defined at the level of the CCMA? It would be nicer if this code, with its relaxation, gave specific circumstances for deviation, or similar to our section 36, where where if there's any limitation of a right, these are the circumstances that give rise to such a limitation. Now, the vagueness of this act puts us in a predicament as labor that we are now at the mercy of chairpersons, we are now at the mercy of employers to say their defense whenever they deviate from this rule, or there is conduct that we deem unjustified as labor when we represent workers in the workplace, and they're able to hide behind this clause to say, no, but the act allows me to deviate if I deem it justifiable. There is no definition for what justifiable is, so we will interpret it in the manner that we deem it fit. So that is problematic on the part of labor. And then I'm going to be mixing this with proposals. Again, I don't want to go back into what the other presenters have already tabled. If we look at what is proposed currently now, the ones that have not yet been gazetted, there's also the discussion around high-paid employees, where now these employees will only be entitled to reinstatement, where it is an automatically unfair dismissal. In any other form of dismissal, it is restricted to compensation as a remedy. Now, the blindness here, or where the blind spot could be here, is when you have such a provision, do you take into account that sometimes dismissals happen consequent to, are not necessarily the employee's fault, right? So let's say whatever happens, whether there's targeting of the employee or there's ill procedure by the company when it comes to certain processes within the company, and then the company dismisses this person. You are literally telling this person that regardless of how you were dismissed, regardless of what happened, as long as it's not an automatically unfair dismissal, you are not getting your job back. And that is a problem for us. As much as it's already been enacted, it's a proposal and it's still at discussion level. It is discussions that as labor, we then need to have to say, when we address the working force or when we address the labor force, they need to understand that these are the discussions that are happening at this level, and if it were to come into play, what would then be the consequence for us, but also how do we then mitigate it as labor? Because perhaps we could look into issues of collective bargaining agreements and see how we strengthen those to further protect ourselves, considering how the act has now become so relaxed, and then we also look at on-call workers. There's proposal around on-call workers, touching on what the definition of employees is. I love how Prof touched on this to say, now the onus to an extent has shifted from employees to employers to be ones that argue whether a person was an employee or not for purposes of the act. And that will really solve a lot of problems that we come across as labor, where whenever a dispute arises, one of the things that must first be addressed is whether this person was an employee or not. And the onus would ordinarily be on the employee to satisfy that they are actually an employee. But now when we look at the type of work that is not ordinarily defined in the act or was not previously catered for in terms of the definitions in the act, we see that now this move towards the definition of employees then allows a greater scope of employees to find enjoyment or to enjoy our labor laws or labor legislations, and they're actually able to organize and to be able to join trade unions and be able to move in that aspect, because they are now deemed employees until the employer themselves are able to argue otherwise. And then lastly, I'm not going to be long. Like I said, I don't want to repeat what has already been touched on by the presenters, but I will say that I'm in possession of the document that has the proposals. So it shows you what the discussions at the level of NEDLEC were in terms of all of the amendments, your BCA, National Minimum Wage, Labor Relations Act, all of the acts in terms of labor. what the discussions were, what the proposals were, what was accepted, what failed. And then I'm also in possession of the Gazette, which was gazetted last year, which shows you the Schedule 8 and what changes have been made. So those two documents could really help someone who's trying to understand where we are in terms of the labor space, in terms of legislation, in terms of implementation, what is still a proposal, what has already been enacted, so that you don't confuse the two, because we tend to see that there is that confusion versus what is still at proposal and discussion level and what forms part of the Schedule 8 as gazetted. But lastly, Natalie, if you look at one of the proposals that was presented on severance pay, there was a question on severance pay now. Initially, the proposal was that, the proposal was that they should be, initially the proposal by Labour was that the BCA should be amendment to increase the minimum statutory severance pay from the 1 week's pay that was currently in force, right, per annum. And then this was, however, accepted by the other constituencies to only a 2 weeks, to a 2 week severance pay per annum, on condition that a transitional provision would be inserted, explicitly stating that the increase would only apply prospectively. In other words, this only applies to completed years of service commenced post the commencement of the Amendment Act. So that is also something that when we discuss the proposals with the working force or students in the labor space, we need to be very specific to say, as much as we seem to be moving, or it seems like in terms of the proposal, the 2 weeks was accepted. It is not a retrospective 2 weeks. It is not a 2 weeks that is going to start from when you started employment. The proposal is accepted on condition that it is prospective. So that will need to be explained to workers, because then you would find yourself in crisis at a time of retrenchment where we now have incoming cases of workers claiming that their severance packages are not in accordance. So perhaps even on our side as Labour, there is an onus on us for proper education, for proper engagement, for proper partnerships with institutions that are able to provide this type of education to our shop stewards, to our organisers, and to ourselves as representatives. Now, on the effect of these on us as representatives, now on myself as a representative, is that we are seemingly seeing an increase in cases where there is deviation on the criminal methodology of it, or procedure that we previously know, to the more relaxed one, but at the mercy of chairpersons, where cases are now being handled in a manner that our shop stewards are complaining to say, either I'm not allowed to cross-examine, I'm not allowed to examine the other party or to test the evidence of the other party. It is just presented and is accepted as is. We are not given an opportunity to test or to question the evidence being led cross-party. So that creates a problem for us as representatives, because it gives an impression that things are just being taken at face value, or we are walking into disciplinary hearings with already predetermined outcomes, where now it is a deviation from the intention of the Schedule 8, where there should be proper consultation, reasonable engagement for purposes of finding a solution. Because just because there's a labor dispute does not mean that the sanction will be a dismissal. The sanction could be, it could be methods. I'm wrapping up, Natalie. It could be methods to find either more education on the program, corrective measures. Yes, that's the word. It could be corrective measures, but we see that we have chairpersons leaning a lot towards dismissals more than any other corrective measures. And then we spend a lot of time with the CCMA. We are taken to the labor court, which we cannot afford. So we have that play of power. So we are really hoping that we'll be able to have engagements with necessary stake players to ensure that as the working force, or as the labor class, or the working community in South Africa, we are able to enjoy these, not just have this legislation, but we're also able to enjoy it, and it's not used against us. Thank you.
Thank you. Really appreciate the clarification on the severance pay. I think it's critical, as well as the distinction between what is already legislation and what is proposed. Adil, Comrade Amakle used some terms like violation and potential misuse. No, I think that she gentled that and made it very, very clear. From the employer's perspective, what is this going to mean? And again, for you as a representative, and I'm also going to throw you the curveball of a question that Danny asked about, is it discrimination for employers who earn more than 1.8 million just based on salary? I wouldn't mind you speaking a little bit to that. And if I could ask Peter to answer the question on how the CCMA will distinguish.
Thank you. I think we're already seeing what the controversy or the nub of the controversy is going to be. And I think organizations like Wits Plus are important in order to empower employers and employees as to how to deal what I have termed, or what the courts have termed, the decriminalized approach to discipline. So the CCMA holds, well, not the CCMA, one of the interpretations is that the amended Schedule 8 only applies to small businesses, or may only apply. So that's certainly one of the interpretations that's echoed by the employee organization as well. It is important that that's going to be a central controversy, whether this decriminalized approach applies to large or medium-sized employers, one, and two, what does a decriminalized approach take? South Africa has been lambasted for having too strict an employment law regime, given our high unemployment rates in this country. Critics have not seen what happens in many other jurisdictions who have far stricter employment law regimes. But this is what we have been dealt with, and we now need to assist parties in ensuring that we deal with the new regime that may take effect or has taken effect. It is important in determining this, and that we go historically as to what our courts have said, and the Commissioner had correctly mentioned the case of Everil Elizabeth Holmes, where our courts have said that employment law does not require or should not mirror the criminal standard and the criminal form when dealing with internal discipline. We then have the 2025 Schedule 8, which certainly my view is that it does not only apply to small businesses, but applies to all businesses, and subject to you not having concluded an agreement, a disciplinary code and procedure which forms part of your collective agreement. And that is fortified by the proposed amendments to the Labor Relations Act at Clause 33, which simply says that all that you require, an employer may, with the consent in accordance with the, sorry, just bear with me for a second. It simply says that you are entitled to hold a hearing provided that it is fair and you are given a fair opportunity. And I'm certainly summarizing those particular provisions in that regard. And the exact wording says, in which an employer has been given an adequate and reasonable opportunity to respond to the reason for dismissal. If one looks at then what Schedule 8 has to say and its interpretation, together with the proposed amendments to the Labor Relations Act, as well as the proposed amendments to the Labor Relations Act, as well as our case authority, provided a disciplinary code and procedure does not form part of a collective agreement or your terms and conditions of employment, you are then entitled to follow what is called a decriminalized approach to discipline. And what do I mean by that? It simply means that the employee needs to be given an opportunity, needs to be told what are the allegations against him or her, to that the employee has been given an opportunity to respond, and a decision is made by a independent person, and this is called the Audi rule. That does not require you to hold what is called a criminal trial disciplinary hearing where you have a chairperson and cross-examination and the like. You simply have to, based on the case authority and our interpretation of Schedule 8, to issue the employee with a letter and ask him or her to make representations and then make a decision. Because our courts have said that the fairness of that termination will be determined by the CCMA. For far too long, we've had a duplication of cost in relation to these disciplinary processes. For far too long, we have asked our people who are not legally trained to sit and act as prosecutors and cross-examine, asking chairpersons to act as judges and arbitrators when they are not skilled to do so, asking employers to employ large HR departments and legal departments simply to deal with ER matters. This is a welcome change. The decriminalization of our disciplinary process is in line with the constitution of a fair labor practice, in line with established case authority. And as our courts have indicated, the time has come for us to stop this kitchen industry that has been developed, where both lawyers and consultants have made money off the backs of employers and employees by complicating and criminalizing a process where all we want to ascertain is the truth in an employment relationship, and the validity of an employer's decision will then be determined by the CCMA. And one of the issues that the WITS Plus causes are going to be dealing with is how do you as an employer, if you or as an employee, if you subscribe to my notion that it applies to all employees, and if you subscribe to the notion that the decriminalized approach applies even to the proposed amendments, is that how do you deal with this new disciplinary regime within the workplace? Practically, how do you deal with it where all you deal with the allegations and the arguments are all on paper, and where you cannot raise preliminary points in the sense to delay a particular matter as such? So that's the first part. The second part is that there certainly needs to be, in terms of high income earners, certainly, unless it's automatically unfair, you are certainly not going to be able to award a high income earner the primary remedy, which is one of reinstatement. The amount that you will be able to award under the proposed Labor Relations Amendment Bill is to still be determined by the minister, but it is unlikely to be more than the maximum, which is 12 months remuneration. This is not a law as yet. What is then to happen is, will there be challenges that high income earners, based on their remuneration, will be discriminated against? Those arguments have been bandied around ad nauseum. You need to determine on what direct ground or stipulated ground are you putting your hat on, and then to show that there's an impairment of your dignity. Now, there's nothing under the prohibition, under the equity regime, which says that you cannot differentiate between income earners, and it is unlikely that such a challenge is going to meet with the court's approval. Thank you, Natalie. Well, thank you kindly.
Thank you. I really appreciate you answering those questions. I see there are a couple more questions that have come through, and I'd like to ask that perhaps we give some answers to that. Prof. Chikte, the question from Bruce Lee that speaks specifically to the definition and the gig workers. Have you got an answer there?
I've put an answer for him. I said, look, I mean, that still has to go through the amendments. But I do think he raises a good point. I mean, sometimes employees may want the flexibility of working as a gig worker, and they may work for a number of different platforms. And I think each case will have to be scrutinized on its own basis. I mean, we need to see how the law is going to treat that. Also, how does the Uber driver go on strike? I mean, people have to be more creative. Unions will have to recruit more. So he raises an important question because the nature of their work is different. And I don't think it's always about whether they're workers or independent contractors. The question is whether or not their rights are whether they're being exploited or not. And I think we're going to have to see how that plays out. I think it's another gray area that's going to have to be interpreted by the courts. All gig workers are going to be the same. Are all Uber workers the same? Some Uber workers may be employees, some may not. I mean, we need to see how the court may interpret. It raises a very good point. People sometimes, yeah.
To be determined a lot. Peter, and if I can ask the panelists to turn the cameras back on because I'm going to be jumping amongst you. Thanks. How will the CCMA distinguish between the genuine failed probation and an employer abusing the system?
Good question. I mean, this is one of the dilemmas that commissioners will be faced with, which we will have to consider. We will obviously be guided and hoping that some case law presents itself very soon. I'm sure we're going to get some test cases as soon as it becomes a part of the Act. But it's difficult. I mean, like I've said, we will have to reskill, rethink, retrain, and go through a mind shift also as commissioners, I believe. Because it's now close to, is it 30 years, more or less? There was one mind shift. Case law took us in another direction, and now we are compelled as commissioners, to actually follow a new train of thought, so to speak. Natalie, it seems that your screen perhaps froze up.
It looks like it has.
I think that's maybe I can respond to something that Adil said and maybe what the union said while it is coming back online. Just this concept of decriminalization, Adil. I know the courts are talking about this terminology, but I don't know. Somehow I feel uneasy with the term when it comes to the workplace, which is a civil relationship in a sense. I'm also concerned when it comes to the process when you're talking about doing things on paper, because sometimes there's an evidentiary conflict that's happening. We need evidence to prove, for example, if the case on theft, and those things can't always be answered on paper. And I know from an employer's perspective, maybe they'd want a process that's much more flexible and it's much quicker and more efficient. Let's use the word efficient. But I mean, don't you think that, it's going to allow for an exploitation of the process where there's a need for evidence, and rather than having a general principle that's saying, look, let's just do it on paper, deal with each case on a case-by-case basis, because that's seems to be what the code is saying. Let's try and be informal, but you've got to look at each on a case-by-case basis, because there will be a need for formal processes. And yeah, so I don't know what your response to that may be.
So just in the last couple of minutes, so certainly those have been some of the arguments that have been bandied, but we deal with this all the time in motion proceedings in court, where a presenter or a judge analyzes these things on paper, and a chairperson, you must give the chairperson the flexibility to ask for information. And this is not unique, right? In the UK, they also deal with it, because the CCMA will determine the sufficiency of evidence. We need to stop holding these two-step processes. Dr. Chika, I just want to deal with two very quick things while I have the mic, which has seemed to come up on the chat. The one is about severance pay and the other is parental leave, but I'll leave that to you. The issue of severance pay, I agree with you that it's not retrospective and it's prospective, and therefore, as an employer and employee, you're going to need to keep meticulous records. It's not yet law, but in future, you're going to see how long was the employee employed, so that you have the 1 week, and then how long the employee was employed thereafter, and you're going to have 2 weeks. As a result of that, what the trade union movement, I'm assuming, is going to do is, in order to neutralize this, is to ensure that they have agreements and retrenchment policies where the 2 weeks will apply irrespective. And we need to then determine that this is going to be on the total, on remuneration and not only on wages. That's a mistake we make when it comes to severance pay. It's on remuneration and not on wages, not only on the cash portion, and we need to be mindful of that. On parental leave, and I see there's some questions on that. There's a host, there's a raft of it available online, but in essence, this is it in the last 2 minutes. If you don't have an agreement between the two parties, they apply equally. Otherwise, there needs to be an agreement, and obviously, as an employer, you're going to need to investigate. If one party is unemployed and sits at home, the other party is entitled to the full amount, and obviously it's unpaid. What you can't do is to pay only the female and not the. You're not only able to pay one person while in a relationship. And Natalie, that's me. Thank you.
Sorry, Natalie. I'm sorry, just a quick one, just on what Adele was saying right now. I happened to sit in one of the discussions of the drafters who are trying to amend the act to include the paternity judgment and what happened in court. And those are one of the things we were considering when drafting the act itself, to say it must not create ambiguity or leave room for such questions. It must be particular to say where there isn't an agreement between the parties, or what protects the father from the mother saying, I don't know this man. So we tried to cater for scenarios like that, to say what constitutes a partner in such a relationship, and then how would the act then apply, and how would the Department of Labor then apply in terms of maternity and paternity leave payouts. So we are trying to curate the act so that it perfectly caters even for such situations. Thank you.
Thank you. That's a valuable addition to that. And thank you, Prof. Ali, for jumping in when we bounced out. For those questions that we haven't answered, but I believe we've answered the bulk of them during this session, we will forward the presentations, we will forward the recording, and we will forward any outstanding answers. A big thank you to all of the attendees on this webinar today, and especially to the panelists for all of your participation. We're bang on 11 o'clock. I'm very impressed with everyone's timekeeping. Thank you and have a wonderful day further.
Thank you.
Thank you very much.
Thank you. Bye, everyone.
Bye.
Bye.